Please be seated. Okay. What's up? These are present, all four defense counsel and Mr. Rodgers. You guys agree to this definition of proffer?
Yes, sir.
Okay. Is there anything else we need with the jury other than bring them back out, read this, and give them a time to come back on Monday?
No. No, sir.
Okay, why don't we do that first? You can bring them out.
You want us to rest in front of the jury?
Yes, ma'am.
But since you didn't say that, no.
Be seated. I'll ask our jurors again, did you follow my instructions not talk about the case among yourselves with anybody else or look up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. We had a request from one of the jurors to define a proffer. A proffer is a meeting between a person under investigation or a criminal defendant and the state. At the meeting, a defendant is represented by counsel and the state is represented by the prosecution. The meeting may be attended by investigating agents. The purpose of the meeting is to allow the suspect or criminal defendant to share with the state information that may be of use to the state. That state?
Your Honor, at this time, the state rests.
Okay. The state having rested, there's some matters that are going to take some time that we have to take care of outside of your presence, so we're going to go ahead and let you go home for the day. I'm going to ask that you not talk about the case among yourselves or with anybody else or look up any of the people or places involved, even though the state is rested. We'll see you again Monday at 10 o'clock. Please be seated. Motions? Yes, sir. Oh, okay. Thanks. Yes, sir.
Thank you, Your Honor. On behalf of Jimmy Ray Rodgers, we would like we will be motioning the court for a judgment of acquittal to the charges of first-degree murder, conspiracy to commit murder, first-degree burglary while armed. The motion for the judgment of acquittal is governed by Florida Rule of Criminal Procedure 3.380. And in this motion, we believe that when the state gets up and in argument against the judgment of acquittal, they're going to argue that their case is not a solely circumstantial evidence case. If it was, it would require a special standard of review and dictates that a JOA should be granted if the state fails to present evidence from which the jury could exclude every reasonable hypothesis except that of guilt. However, in Ehrlich v. State, 742 Southern 2nd, 447, 4th DCA, and I have provided the state with all case law that I'm going to be citing to. I have presented the court copies as well. In that case, the court utilized a special standard of review for circumstantial evidence cases, even though in that case the tape of the defendant's statement was admitted. Notably in Fitzpatrick v. State, 900 Southern 2nd, 495, the Florida Supreme Court in 2005, the court refused to use the special standard for circumstantial cases because DNA and eyewitness testimony had been entered. In this case, other than the statements of Taylor Showmaker and Curtis Wainwright, the evidence introduced by the state is circumstantial and is not inconsistent with the defense theory of events. There are no fingerprints, there are no DNA, no eyewitness testimony, recordings, emails, cell phone records, bank statements, etc. that provide substantial competent evidence or directly connect Jimmy Ray Rodgers with planning or participating in the homicide and or burglary. Furthermore, even if the state had introduced substantial competent evidence that Jimmy Ray Rodgers was present at the scene, mere presence alone is insufficient to establish a burglary or planning, intent, premeditation, or participation in murder, citing Taylor v. State, 747 Southern 2nd, 393, second DCA case in 1996. There is insufficient substantial competent evidence to convict Jimmy Ray Rodgers of first-degree murder under 782.04 sub 1, 777.011, 775.087. The only evidence that could potentially establish evidence of Jimmy Ray Rodgers' presence at the scene of the murder or participation in the murder were the statements of Curtis Wainwright and Taylor Showmaker. Both of these statements are unreliable. Curtis Wainwright's statements are full of inconsistencies and lies, and further, his eventual admission to his own participation in the crime and his implication of Jimmy Ray Rodgers' involvement were the result of his desire to save himself from the death penalty and the detectives feeding him the narrative they wanted to hear. Likewise, Taylor Showmaker's statements contains inconsistencies and is the result of the detectives feeding her the narrative they wanted to hear, intimidating and isolating her, placing her in fear by creating a show of force, threatening her with prison and to take her children from her, and offering her a substantial sum of money to cooperate and provide testimony that would result in the conviction of Jimmy Ray Rodgers, Curtis Wainwright, and Mark Sievers. For the same reasons, there is also insufficient substantial competent evidence to convict Jimmy Ray Rodgers as a principal on this count, as well as the other counts with which he is charged. First, Jimmy Ray Rodgers lacks the requisite intent and participation elements of principal liability. The only evidence that Jimmy Ray Rodgers assisted in the planning or commission of the murder are the statements by Curtis Wayne Rodgers and Taylor Showmaker. Additionally, as stated earlier, there is no competent evidence other than Mr. Wright's statement and Ms. Showmaker's statement that Mr. Rodgers was at or in the home, or that he was there uninvited, that anything was stolen, or that he participated in any crime that could constitute conviction for burglary while armed. Jimmy Ray Rodgers believed he was going to Florida because Curtis Wainwright asked him to go with him so he could help with the drive. The evidence showed Curtis Wainwright cannot drive long distances without falling asleep. Jimmy Ray Rodgers had never been to Florida, so he took pictures throughout the trip, and he bought souvenirs to take back home. He also brought and used the cell phone and the GPS Curtis Wainwright had in the vehicle. Jimmy Ray Rodgers made no attempt to hide the fact that he was in Florida, and as Curtis Wainwright said, he acted like he had nothing to worry about. And that was because he had no idea what Curtis Wainwright's plan was. As for the actions Curtis Wainwright claims Jimmy Rodgers took after the murder, i.e. helping to dispose of the uniforms, tape, phones, etc., at most they may establish Jimmy Ray Rodgers was an accessory after the fact, but they do not amount to him being a principal or in any way participating in planning or carrying out the alleged murder or burglary while armed. Furthermore, his actions after the murder were the result of duress, intimidation, and fear. He certainly had reason to fear for his own life after discovering what Curtis had done to Dr. Sievers and knowing who Curtis Wainwright was. As for his principal, whoever commits any criminal offense or aids, abets, counsels, hires, or otherwise procures such offense to be committed, and such offense is committed or is attempted to be committed, is a principal in the first degree and may be charged, convicted, and punished as such, whether he or she is or is not actually or constructively present at the commission of such offense. To convict, the state must show both that Jimmy Ray Rodgers assisted the perpetrator, that would have been Curtis Wainwright and or Mark Sievers, by doing or saying something which was intended to and did incite, cause, encourage, assist, or advise the other person to actually commit the crime. In this case, other than the statements made by Curtis Wainwright and Taylor Showmaker, no competent substantial evidence was presented to prove that Jimmy Ray Rodgers assisted, aided, abetted, counseled, hired, or otherwise procured the offense to be committed. Furthermore, there is no evidence other than the statements of Mr. Wright or Ms. Showmaker that Jimmy Ray Rodgers participated in the planning of the crime, or that he was aware of the plan to commit the crimes alleged in the indictment, or that he was present when the crimes were committed. Nor is there any evidence that Jimmy Ray Rodgers had knowledge of the plan or of Curtis Wainwright's intent to commit the offenses. However, even if Jimmy Ray Rodgers had known, that is insufficient to fulfill the participation element. And we would cite to Shadoin v. State, 362, Southern 2nd, 398, 2nd DCA of Florida in 1978, and Christie v. State, 652, Southern 2nd, 932, 4th DCA, 1995. The state cannot point to any evidence other than Curtis Wainwright and Taylor Showmaker's statements that Jimmy was part of the planning of this crime. There are no texts, emails, voicemails, bank statements, or other evidence of monetary or economic gain or sharing of proceeds associated with the homicide linked to Jimmy Ray Rodgers. Furthermore, the other evidence introduced by the state, such as the videos of him at Walmart and gas stations, phone logs, Garmin data, photos, T-shirt, cooler, work jumpsuit, are consistent with innocent activity and without more do not point to criminal intent or actions. The state cannot point to Jimmy Ray Rodgers driving back to Missouri with Curtis Wainwright after the homicide to bolster the principal argument or their argument that he committed the murder and armed burglary. If anything, this act would be indicative of the crime of accessory after the fact, not principal liability, and we'd be citing to Pack v. State, 381 Southern 2nd, 1199, 2nd DCA, 1980. Evidence of flight, etc., was strong evidence of accessory after the fact, but did not show specific intent to aid and abet commission of the crime. Cite to Cornejo v. State, 892 Southern 2nd, 1160, 4th DCA, 2005. In that case, actions post-shooting were consistent with someone who was an accessory after the fact, not with principal liability. The second thing that the state would have to prove is that Jimmy Ray Rodgers intended to participate in the criminal conduct of the principal. Citing to Howard v. State, 473 Southern 2nd, 841, 1st DCA, 1985. Owens v. State, 289 Southern 2nd, 472, Florida 2nd DCA, 1974. A standard where evidence of participation and intent is not circumstantial. There's two different ways. We must simply ask whether the defendant intended to participate in the crime. The state may prove intent either by showing that the defendant had the requisite intent or that he knew the perpetrator had that intent, and that is Messer v. State, 757, Southern 2nd, 526, 4th DCA in 2000, and Stark v. State, 316, Southern 2nd, 586, 4th DCA, 1975. The standard where evidence of participation and intent are purely circumstantial, the proof must not only be consistent with guilt, but also inconsistent with any reasonable hypothesis of innocence on every element of the crime charged. To do so, the state must present competent testimony or physical evidence to impeach or contradict the defendant's version of events. Citing Tillman v. State, 842 Southern 2nd, 922, 2nd DCA 2003, State v. Law, 559 Southern 2nd, 187, Florida Supreme Court, 1989, Rawson v. State, 319 Southern 2nd, 64, 2nd DCA, 1975, and Lockett v. State, 262 Southern 2nd, 253, 4th DCA, 1972. Where two or more inferences in regard to the existence of criminal intent and criminal acts must be drawn from the evidence and then pyramided to prove the offense charged, the evidence lacks conclusive nature to support the convictions. Citing Gustine v. State, 97 Southern 2nd, 207, and Shadoin v. State, 362 Southern 2nd, 398, 2nd DCA, 1978. The court looks to the totality of the circumstances to determine whether the state has met its burden. Now, the state may point out that proof of mental intent is seldom accomplished by direct evidence. Consequently, the absence of direct proof on the question of defendant's mental intent should rarely, if ever, result in a JOA. That's in Ehrlich v. State, 742 Southern 2nd, 447, 4th DCA, 1999. However, in Cornejo v. State, 892 Southern 2nd, 1160, the 4th DCA in 2005 tells us, involvement in underlying feud in that case and presence at a murder scene is insufficient to convict at principle for second-degree murder where the defendant has no knowledge of co-defendant's murderous intent, that's evidence consistent with accessory after the fact. In Cornejo, A rival gang feud led to the defendant being charged with first-degree murder as a principal. Convicted at trial of second-degree murder, state acknowledged that although the defendant and his friends had surrounded the victim, the defendant did not fire the shots that killed the victim. The court noted that physical evidence of blood and a screwdriver turned murder weapon found in the car with the defendant were not probative of his actual participation in the shooting. Nothing in the evidence overcame the reasonable hypothesis in Cornejo that he had any knowledge of any plan to shoot the victim. He had offered no assistance or encouragement that led to the shooting. In this case, the presence of the items law enforcement collected as evidence and determined were Mr. Rodgers, i.e. cell phone pieces, the uniform, the phone items purchased at the Walmart, are not probative of his participation in planning or participation in the murder, and not sufficient to overcome the hypothesis of innocence that Mr. Rodgers had no knowledge of the plan, that he offered no assistance or encouragement that led to the murder. However, certain of the actions taken after the murder and some of the items collected as evidence may be consistent with being an accessory after the fact. In Jaramillo v. State at 417 Southern 2nd, 257, the Florida Supreme Court in 1982, if the state's evidence is not actually inconsistent with the defendant's version of events, then the state has not overcome its burden. In Jaramillo, the JOA was denied at trial and reversed on appeal when the Florida Supreme Court held that circumstantial evidence that the defendant's fingerprints were found at the murder scene was insufficient to support the conviction, where the state failed to show that his fingerprints could only have been placed there at the time of the crime. Importantly, the fingerprint evidence was not inconsistent with the defendant's version of events. He testified at trial that he'd been helping a resident move boxes in the home some days before the murder. In this case, the state has presented no fingerprints or DNA that are matched to Mr. Rodgers from the home. Furthermore, even if fingerprint or DNA evidence had been found and matched with Mr. Rodgers, it would not be inconsistent with a reasonable hypothesis of innocence that he went there with the intent to drive Mr. Wright down to Florida, and that he just came down to spend a few days in Florida and had no knowledge of the plan to murder Dr. Sievers and no participation in the murder. Taylor v. State, 747 Southern 2nd, 393, 2nd DCA in 1996, mere presence is insufficient to establish the participation element of principal liability, as is driving the perpetrator to or from the scene. In Taylor v. State, it involved an armed robbery of a woman outside of a gas station. The state demonstrated A, that the defendant was present at the crime scene with another man, B, that he was the driver of the getaway car when it left the scene when it was stopped. The motion for JOA at trial was denied, and the defendant was convicted of 2 counts of armed robbery. The convictions were reversed on appeal because the state's evidence did not exclude the reasonable inference that the defendant was waiting for his friend to return to a car. The mere presence at the scene and or mere knowledge that a crime was being committed are insufficient to establish participation. Additionally, driving the perpetrator to and from the scene or a display of questionable behavior after the fact is insufficient to establish participation. In this case, the reasonable hypothesis of innocence includes Mr. Rodgers driving to Florida with Mr. Wright for the purpose of helping him drive and to spend some time at the beach. Per the holding in Taylor, the mere fact that Mr. Rodgers drove with Curtis Wainwright to Florida is not sufficient to establish participation in the crime. Furthermore, based on the court's holding in Taylor, even if Mr. Rodgers knew of the plan but did not participate in planning or carrying out the murder, the fact that he waited outside or in the car for the murder to take place would not be sufficient to show participation in the planning of or participation in the murder. Citing Pack v. State at 381 Southern 2nd, 1199, 2nd DCA in 1980, post-crime flight from police is probative of being an accessory after the fact. It is not to be used as evidence of specific intent required of a principal. The facts in Pack are similar to the facts in Taylor. In Pack, the case involved 2 brothers, and evidence was presented could not refute The reasonable hypothesis that the defendant accompanied his brother to the drugstore but knew nothing about the robbery at the time of their departure. Although the flight from the police is strong evidence that the defendant might have been an accessory after the fact, it does not show the specific intent to aid and abet. In this case, evidence that Mr. Rodgers drove to Florida with Curtis Wainwright, was at the home with him, left with him after the murder, and drove back home are not sufficient to establish he participated in the planning or murder of Dr. Sievers. Even the actions taken afterwards, if taken like most favorable to the state, getting rid of phone pieces or the uniforms, are insufficient evidence to show the specific intent required for a principal, and at most, once again, may be probative of him being an accessory after the fact. Citing Davila v. State, 988 Southern 2nd 35, Florida. Evidence, including a defendant's own statement, established that the defendant knew his friends, fellow gang members, were hit a lick. The others did rob an elderly man and beat him to death. The trial court denied the JOA, and the defendant was found guilty of conspiracy to commit robbery and attempted robbery, and found not guilty to commit a robbery, and his presence in the vehicle as the crime occurred were not enough to be construed as participation. Citing Hedgeman v. State, 661 Southern 2nd 87, 2nd DCA, Florida, 1995. Presence at the scene and involvement in underlying altercation is insufficient without knowledge that co-defendant intended to kill. In that case, the defendant was charged with first-degree premeditated and felony murder. Evidence established the victim was involved in an ongoing altercation about a debt with the defendant and co-defendant. The defendant was present when the co-defendant shot the victim, but the state could not establish he knew the co-defendant had murderous intent. The JOA was denied at trial, and the defendant was convicted as a principal to second-degree murder. The conviction was reversed on appeal because, quote, absent any testimony to establish that the co-defendant planned to kill the victim that night and that the defendant knew of his plan, there is no evidence that the defendant intended that the crime be committed, end quote. In this case, there is absolutely no evidence, once again, other than the statements which have been refuted, made by Curtis Wainwright and Taylor Showmaker, that Mr. Rodgers knew of Mr. Wright's and Mr. Sievers' plan to kill Teresa, and no evidence that he planned or intended that the crime be committed. Citing to Ginebra v. State, 787, Southern 2nd 51, 2nd DCA, 2001. Without anything further, a defendant who admits presence at a murder scene but denies participation has not participated so as to fulfill the elements of principal liability. In Ginebra, evidence linked the defendant to a drug deal that was the basis for the killing, but the only evidence establishing his involvement with the murder was his own statement that I was there but I didn't shoot anybody. The JOA motion was denied at trial, and he was convicted as a principal to second-degree murder. The verdict was reversed on appeal because no evidence has been presented that the defendant intended or participated in the murder. The mere presence or knowledge of the crime was insufficient. Your Honor, in this case, the testimony of Dr. Coyne was that the injuries that Dr. Sievers suffered are consistent with a single weapon, and the state tried to get him to say, well, maybe it can be more, but it is consistent with a single weapon, not maybe it's not. It is consistent with a single assailant. We know who the single assailant. They have the hammer. Curtis Wainwright took the stand, said that was the hammer he used to strike Dr. Sievers. If the state's evidence is from their own witness that it's consistent with a single weapon and a single assailant, it shows that Mr. Rodgers was not a participant in this heinous murder. I think it is most telling when trying to evaluate the testimony of Curtis Wainwright that he claims he did this to protect Dr. Sievers' children by murdering her. And that is the type of person who would take 17 swings at an innocent victim, and then look her children in the eye and hug them at her funeral. There has been no presentation of any evidence other than Curtis Wainwright that Jimmy Rodgers participated in this. For those reasons and for the cases cited, we ask for a judgment of acquittal. Thank you.
State.
Your Honor, in ruling on a motion for judgment of acquittal, the court must regard all facts introduced in evidence as admitted by the defendant and must indulge every reasonable inference in favor of the state. That is the point of trial where we currently are. A motion of acquittal should not be granted by the court unless there is no view of the evidence which the jury might take favorable to the opposite party under law. So I want to start there, and I want to very briefly, Your Honor, but I do want to start by noting that Mr. Brazel cited and said a number of facts as if they were evidence, and there has been no evidence of that before the court. There is no evidence before the court that in terms of why Mr. Rodgers drove down here simply to assist in the driving. There is no evidence before the court that Mr. Rodgers has never been here in Florida. There's no evidence in front of the court that Mr. Rodgers was intimidated. And the list could go on. What the court must consider is only the evidence that has been presented to the court at this time. So starting with count 2, which is the premeditated and felony murder count. Your Honor, and the state has 2 cases that the state will give to the court. But the state has to show that the victim is dead, that death was caused by the criminal act of the defendant, and that it was premeditated if it's premeditated, or if it's felony murder while engaged in the commission of a felony by the defendant or his accomplice that caused the death of the victim, and no premeditation is needed. And the evidence that's been introduced, Your Honor, is sufficient. The 2 cases I want to give to the court are Jones versus State and State court, and a copy to defense of each of those. Those are Jones versus State at 36 Southern 2nd, 903, and Pierce versus State at 800 Southern 2nd, 561. Pierce is a Florida Supreme Court case. Jones is a 4th DCA case. As Jones said, premeditation may be inferred from the nature of the weapon used, the presence or absence of adequate provocation, previous difficulties between the parties, the manner in which the homicide was committed, and the nature and manner of the wounds inflicted. That's what Jones says. Pierce says, premeditation is a fully formed conscious person to kill that may be formed in a moment and need only exist for such time as will allow the accused to be conscious of the nature of the act about to be committed and with the probable result of the act. The evidence in this case is that there was blunt trauma and at least 17 crescent-shaped and irregular lacerations, frontal, posterior, right, and left sides of the scalp, bruising on the arms with circular bruises. There is also, good with that, there is the statement of Taylor Showmaker that Rodgers admitted killing to her and killing the victim with a hammer. In addition, there is the statement of Curtis Wainwright, which make it clear that Mr. Rodgers was present, was aware of what was to occur had been part of the planning process. And so the evidence as has been introduced, into which the court must give all inferences in favor of the state, makes clear that the state has met its burden as to the first degree and felony murder. As to the third count, which is the conspiracy count, the cases are clear that circumstantial evidence, if sufficient to show beyond a reasonable doubt the existence of the elements of the agreement and an intent to commit the crime, that's the subject of the agreement, that may be the basis of a conviction, and that's Wyant versus State, which is at 659 Southern 2nd, 433. I just pulled these up. And in a most recent case that just came out, I will give the court, and I have copies for both the court and for defense counsel, the Newcomb case, which is at 2019 Westlaw 4249634. And Your Honor, I'm handing a copy to defense counsel and copies to the court.
Thank you.
Newcomb says a conspiracy exists when there is an expressed or implied agreement between two or more persons to commit a criminal offense and an intention to commit the offense. The jury may infer the agreement from the circumstances. Direct proof is not necessary. A defendant may be found guilty of conspiracy if he had knowledge of the essential objective and voluntarily became a part of it, even if he lacked knowledge of all the details of the conspiracy or played only a minor role in the total operation. And Newcomb cites another case. I haven't presented a copy, but it cites the Cummings versus State, which is at 514 Southern 2nd, 406, specifically at 408. And that would be a fourth DCA case out of 1987. As Wyatt said, circumstantial evidence can be sufficient to show the intent of the crime. And in the that Curtis Wayne Wright spoke to Jimmy Rodgers on May 17th, that Jimmy Rodgers agreed at that time to participate in the murder of Teresa Sievers, that those plans were firmed up over the next couple of weeks, that Curtis Wainwright had told Jimmy Rodgers that he wanted him to kill somebody, that he told Jimmy Rodgers of the possible plans and sought Jimmy Rodgers' feedback. He testified that they drove down versus flying to not leave a trail. He testified that Jimmy Rodgers knew he paid from the rental car for advanced money for the killing. He testified that Jimmy Rodgers brought a cooler with duct tape and industrial latex gloves. He testified that Jimmy Rodgers brought a backpack with 2 sets of coveralls. And the testimony in trial is that those coveralls came from the plant where Jimmy Rodgers lived, the very plant where he had obtained information that the purpose of those coveralls was to prevent the exchange from the outside into the inside, and certainly the inference would be the inside to the outside. Husband of the victim upon the receival of life insurance proceeds, and that Jimmy Ray Rodgers, before the murder, before Teresa Sievers returned to her home, picked up a hammer and made a joke about it being Teresa Sievers' destiny by making a swinging motion with the hammer. but it is not to Curtis Wainwright alone. Taylor Shoemaker asked Jimmy Ray Rodgers if he had killed someone. He said, yeah. If he had shot the person, no. How it had happened, and he said with a hammer. And she testified he told her he was being paid $10,000 from the insurance policy of Teresa Sievers. And even to that, we have the fibers that were found on the leg of Teresa Sievers during the autopsy. Those fibers were found by our FBI analyst, Linda Ottestatter, to be her specific language, but to be fibers that had the same characteristics for the entire examination, all six characteristics comparing, or seven depending whether it was the nylon or the cotton, and through all 5 levels of comparison. So that the fibers that were on the suit that was found on the side of the road, a suit that takes that suit out, that is more than strong circumstantial evidence, Your Honor. There is direct evidence that Jimmy Ray Rodgers participated in this, as well as the indirect evidence. Conscious acts of concealment and false statements are something the court can consider, as was found in the Spioch case, S-P-I-O-C-H, at 706 Southern 2nd, 32, page 35. That was out of the 50 CA in 1998. The state that this was a stealthy entrance done at night through a garage door. As Mr. Wright testified to the neighbors, they did not want the neighbors to see. This was a stealthy entrance. The state has met its burden and asked the court to deny the defense motion for judgment of acquittal.
Yes, sir.
This court has never indulged burden shifting in my years before it. I expect the court will not indulge burden shifting in this case as well. When the state talks about that Mr. Rodgers didn't have permission, nobody came in and testified that he had permission. No, the state has to prove that there wasn't permission. And if Curtis Wainwright had permission, for the state to say, well, it's okay for Curtis Wainwright to come in and murder somebody and it's not a burglary, and then say, oh, but with Jimmy Ray Rodgers, it's a crime, that's a burden shifting. That cannot stand. There is no evidence of conspiracy. The only thing on a conspiracy is based on trusting the words of Curtis Wainwright. Yes, Curtis Wainwright. We know he struck Dr. Sievers with that hammer. We know Dr. Coyne says it's consistent with one weapon, consistent with one attacker. So now for the state to say, but we should believe him on everything else, when he talked his way out of a potential death sentence, when he lied not only to the police, when he lied to the state attorney, when he was doing his proffer, when he was given another chance, when he finally told the story that they wanted to hear, and say, but that's evidence of a conspiracy? You can't trust the words of Curtis Wainwright to base any conspiracy. There's been no evidence that Mr. Rodgers knew anything that was going to happen. And as the state pointed out, they came down. What type, if we're going to believe Curtis Wainwright, what type of person who is going down with the intent of murdering another person rents a car in his own name, gets a down payment from the victim's own bank account sent to him, has somebody else with a phone taking pictures on the way down, plugging in a garment. The $600, it's very interesting. If we're to believe Curtis Wainwright that $600 on $100,000 down payment crime. That's the down payment. Ms. Fitzgeorge brought out from Curtis Wainwright. Well, I'd get paid about $100 a month, and I'd get paid about every 6 months, every so often. That's where the $600 came from. He changes his story. The detective says he tells stories that are convenient to him. And that is what the state wants you to say, well, that's proof of a conspiracy, even in a light most favorable to the state. They went and bought souvenirs. They purposely went into a Walmart with 85 cameras. He knows they have 85 cameras because Curtis Wainwright was the person who's evidently installing them in Missouri. Who has a plan to go murder somebody and leave such a trail of breadcrumbs? He will lie to save his skin. The state has made its Faustian bargain, and they're stuck with him. And now they're asking you to say, well, that's enough to show a conspiracy with Mr. Rodgers.
Okay. I want to look at the cases both sides have presented to me, so I'll reserve ruling at this time. You guys want to wait, or you want to just hear give me time until Monday? Monday's fine? Okay. I'm going to have you guys come back at 10 o'clock as well. Why don't we make it 9:45? I've got other cases set for trial call and for pleas on Monday, so I'll be a little busy starting at 8:30. Anything else we need to address?
Sir?
If we move on to the defense on Monday, how many witnesses approximately do you have?
Potentially,
I'm only asking because you didn't read any names to the jurors, and we only retained, I think, one person out of the 30 witnesses or so we had. So just trying to get an idea where we're at.
there are several witnesses that we did ask to be retained that were not released on our request, and we will be discussing that this afternoon
All right.
with Mr. and over the weekend with Mr. Rodgers on how we will proceed. So,
I would ask both sides to prepare any closing argument statements that you have as well, because if we get to that point, I don't think there'll be a gap. We'll go right to it, other than a standard gap of 20 minutes or whatever. Anything else?
Just one final thing, Judge. I took responsibility for drafting the state's proposed instructions. I hope to finish them this evening. So I'm guessing if the court's going to conduct a charge conference, it'll be at the close of the defense case.
That's when I normally do it.
Okay. So if it's okay with the court and with counsel, I'll email those to the parties and to the court as soon as I'm done with them, if not tonight, tomorrow morning.
Okay. And if we get to that point, there were additional instructions I think we read at one point or another that you might want to include.
Okay, I don't think I have copies of those. I'll work with counsel on that.
Okay.
yes, sir.
All right. See everybody Monday. No one's going to take a trial from me on Monday. No, we don't need it. Yeah. You can use Court Smart in the morning, right? So if you don't want to get here at 8:30, you don't have to. We can use Court Smart until we get to them, unless you want to be here.
Do you have any capital or
I don't
cases
believe
required?
so.
You don't think so? Okay. I'll check. My office will